Hi, good afternoon, everyone. I'm Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna PC. We try to do these calls on a bi-weekly basis, subject to busyness with other work, and we've had a long gap because of the H-1B quotas. Very busy season. So until we get busy again with the RFEs, we'll try to do it every 2 weeks. You would have heard our standard disclaimers when you logged in that participating in this call does not establish an attorney-client relationship and that we do the best we can with the information we have. This is not a substitute for an in-depth consultation. That said, let me begin with the questions that I consider are frequently asked questions, after which I will ask you for any follow-up questions you have on the questions that I've answered. Then we'll deal with the regular questions. I doubt very much we'll have time for new questions, but if your question pertains to something that follows directly from what I've discussed, feel free to ask. First question is from Manglesh. First of all, I don't know if you folks have kept in touch with this. I'm sure you have. Curricular practical training has become quite a painful issue. Government has tried to make every exemption they can to catch hold of people and try to make things that were legal until yesterday illegal today. So one of the things that they've done with curricular practical training and practical training in general are, first of all, they say that CPT and OPT combined cannot be more than a year at any one educational level, unless you've got, of course, the STEM extension being the exception. So it becomes a problem if you have one master's degree and go for another master's degree, and you've already taken 1 year of OPT, taking CPT would be considered to be putting you out of status. So Manglesh says, my lawyer says that we should change to consular processing. I personally don't see why, but of course, if that's what you want to do, that's your choice. I would let them decide the case, because what is the worst they can do? They can only ask you to go for consular processing. Although there is a very odd little piece, again, of law that says students start accruing unlawful presence when they break status. Can they impose this upon you? I do not know the answer to this question. So all in all, I think changing to a consular processing is one of the ways you can go. Depends upon how aggressive you want to be. If I wanted to be aggressive, I would just resist them and I would say this is not applicable and you've not made any public notification of this issue. You've started interpreting the regulations differently than you used to, and that you cannot do without making new regulations. So it depends upon how aggressive you want to be. But if you want to be more conservative, go ahead and change to consular processing. Personally, I think if the consulate wanted to make the same issue, they could. *5 if you have a follow-up question on this. Press *5. Okay. Let's go on to the next frequently asked question. Okay, guys, you got to be a little quick about this. So there's a follow-up question on this from Minnesota. All right. Minnesota, go ahead, please.
I have a follow-up question on Manglesh's question.
Right.
Why did you say that going through consular processing would be a more conservative way to approach this? What guarantee does Manglesh have that once he goes back to India or wherever, the consular officer will not decide that he has violated his F1 status and as such is subject to a 3-year bar from coming to the U.S.?
When you listen to this recording, listen to my last sentence. I said exactly that there's no guarantee. Okay?
Okay.
It's just a more conservative approach because I know of many people who've done this and they've not had a problem. That means consulates so far are not making it an issue. But is there any guarantee they won't tomorrow? None whatsoever. I think this whole approach that the Trump administration has taken to creating policy on the fly without appropriate notice, it leaves much to be desired. I think that, in fact, there are a couple of cases pending right now against their student visa interpretations. There's one pending in North Carolina, filed by 2 universities in North Carolina. So I think this whole approach to making policy on the fly and leaving people in trouble, it's very, very shady at best. Depends upon how much we can convince a judge to look at. I think this is an improper way to implement it. Is it illegal? In my opinion, yes. So to answer your question, is there any guarantee? No, and I said that. Okay. All right, guys. Next question is options to stay in the USA after expiration of H-1B. Oh yeah, by the way, one more comment. Why consular processing might be less problematic. One, because of our experience. Second, when you ask for a change of status, then having maintained status is the main issue in that. Once again, when you ask for change of status, having maintained your status is a pivotal issue. But in consular processing, it doesn't matter if you've maintained status or not, because visa stamping gives you status all from the very beginning. Options to stay in the USA after expiration of H-1B. Not very many, guys. As you know, you've got a 60 days grace period. And that 60 days, the way it works is upon cessation or termination of the employment, you've got 60 days or the time remaining on your I-94, whichever is shorter. But beyond that, you don't have any other way of staying. People go and apply for tourist visa or student visa within the time permitted by law, and that includes the 60 days. So can you file for a tourist visa during that time? Yes, and the answer is you can, but are you going to get it? Who knows? But it could take several months for the government to decide, and during those months, you are not out of status, okay, or unlawfully present. So you are what is called an authorized period of stay. Questions are, first question was, what are the options available to legally stay? I don't think you would get the tourist visa or tourist status, but you can apply for it. Without a job, how many days I can stay in USA before my I-94 expires using I-140? 60 days is the total time. *5 if you have a follow-up question on this. *5. Okay, let's see. We have a follow-up question from Pennsylvania. Pennsylvania, go ahead, please.
Hi, Rajiv. Good afternoon.
Good afternoon, sir.
This is the question I posted. Say during this time, if I get like an employment with like a 2 employers, like A and B, so can I do parallel processing of H1 with both of them, or do you think anything negative on that?
See, I cannot comment about contract law, but under immigration law, you can apply for as many H-1B transfers as you like, not just 2. You can do 20 if you like. Okay.
At the same time, and
yes,
we can do.
Absolutely.
Okay, Rajiv. Thank you very much.
Oh, you're welcome. Good luck.
Thank you.
All right. So going to the next frequently asked question. How to get H-1B approved for 3 years, not a shorter duration? Well, this is another problem. This administration, actually before that, to be fair, that even before Trump administration, Obama administration had started insisting, we will give you an H-1 only for the duration for which you have a project. So if you have project documentation with a work order of for, let's say, 6 months or 7 months, you will get your H-1B typically for only 6 or 7 months. Some of the exceptions are where you've got, let's say you've been getting 6 monthly approvals for the last 2 years. You can try to convince the government that they give us project extensions on 6 monthly basis, but the project is ongoing. I doubt very much the government is going to be sympathetic to your situation. Typically, the only way you can get 3-year extensions is if you can prove that the project will go on for 3 years. Those projects are, again, typically those the work is in-house, or you actually have a client letter that says we are going to have this project for 3 years. Star 5 if you have a follow-up question. Star 5. Okay. Let's just read the rest of the question. Got my H-1B approved for a period of 1 year, expires on October 27th. Any precautions I can take to get 3-year extensions? And the answer is what I gave you. Any particular documents needed? Typically a client letter. If I go for stamping, do I need to be careful with social media? Always. Your social media, for instance, if you have your title as software developer for the H-1B and your LinkedIn profile says that you're a VP operations, you have a problem. So even though you might be updating your social media profile to look good and maybe exaggerate a little bit, it can cause a problem for you. Make sure your social media is not in any way in contravention or opposition to what you have been saying to the government. Yeah, just make sure that your social media accords with your professional life as presented to the government. My EBT priority date is Feb 4th, 2015. Girl is a Nepali citizen. He's getting married. Yes, of course. Once you get married, you are entitled to cross-chargeability, and you can be charged under Nepal's category, which is available right now. Okay. If yes, what would be my next steps? As soon as you get married, you should have your lawyers write to the government and ask for cross-chargeability. Probably within a few months, you could be scheduled for an interview. Depends upon how busy the local office where your case goes is. So if the local office is very busy, it could be longer. Star 5 if you have a follow-up question. Star 5. All right. Next frequently asked question. Are we done? Okay, I guess we are done with the frequently asked questions. Now let's go back to our regular questions. By the way, I have, sir, don't raise your hand after I have done answering the question several minutes later. It's difficult to keep going back. I'll make this exception, but when I ask for you to raise your hand, please do it then. Go ahead. Wisconsin, go ahead. Yeah.
I think you missed my frequently asked question.
Oh, did I? Oh, I'm sorry. Give me 1 second. Give me 1 second.
That's why I raised the hand.
Oh, thank you.
So sorry for
I appreciate. No, I am sorry. Because I assumed that you were asking a question about something. Give me 1 second. Multiple years of CPT, expiration of H-1B.
What about D1, D2 extensions?
Oh, yes. That's an important one, actually. How to get H-1B approved.
I'm sorry.
No. Absolutely not. My apologies. Where is it? I remember reading that question.
It was like second or third from the bottom.
Huh. I don't see it anymore. 16.
Rahul Gopal Joshi. हम पहले बात कर चुके हैं.
1 second. What did I do with it? I did read it, I know for sure. Oh, is there a second page maybe? Give me just a moment. I'm trying to locate the question. There's a total of 16 questions. Do you know your question number by any chance?
I think it was 11 or 12, I think.
Okay, let's look
I
at
can
it.
double check.
11 is 180-day rule. 12 is something totally different. Yeah, but I did read your question, I know, and I marked it as a frequently asked question.
Give me a second. I'll tell you the number, sir.
Okay. But I do remember the content of your question. Eventually we'll find it. I remember that you were saying that your parents needed 2 or 3 months extension and that that they were here on a B1, B2, and they had a 10-year multiple entry. And you also said...
Question number 9.
Question number 9, okay. And you also said, do we need to present a return ticket? And the answer is, as far as I know, they do ask. Oh, here it is. It was a frequently asked question. Maybe I didn't mark it as frequently asked. Okay.
Question number 9.
Right. I see it. And actually, like I said, I remember it. So do they require that kind of evidence? And the answer is yes, they often do require a return ticket. I'm always hesitant to apply for a tourist visa extension unless I know the reasons and unless I can update you completely about what the issues are. See, typically, when somebody comes to USA on a tourist visa or even a business visa, they get 6 months stay. They have stayed here 6 months. Now they want to extend it. There's got to be a good reason for it. Okay? Because if they stay here more than they stay in their own country, government says it looks like you are visiting India and staying in USA. Okay? So there's definitely a possibility of a problem in re-entry if they come back too quickly. So let's say they got another 3-month extension, then after 5-6 months they want to come back again. Customs and Border Protection can turn them back, saying that you've come back too quickly and you've stayed here too long. Similarly, in your father's case, your parents' case, it's not a problem. If they apply for a visa and they have a history of staying a long times in USA, even with legal extensions, consulate can give them trouble with the visa stamping. So I would avoid it, and I would ask for, if 3 months are needed, I would ask for only 3 months time. I wouldn't ask for 6 months when I apply for an extension. Now, the extension is not likely to come in the time that you have asked for, whether it is 3 months or 6 months. So what happens is that if you have applied for an extension within the life of the previous stay period, you are considered to be maintaining lawful presence. So it's called authorized period of stay. Authorized period of stay. And you leave during that period. You have left the USA, and if the case is denied in your absence, it isn't a problem. But you must keep a record of having applied for this. So if I were you, I would keep a copy of the application on the cloud or something where your parents can access it if there's a problem, and a receipt notice, and even the final decision. Also, I would keep a copy of proof that I actually left on XYZ date. That proof could be a copy of the boarding pass. They can take a picture of it. It can be a copy of entry stamp that they get when they go back to India. So basically what you're trying to prove is that an extension was applied within time, that the extension stayed pending, that they left within that period which was contemplated in the extension, and they did arrive back in India during that time, and that ultimately what happened to that case. So all that becomes irrelevant, but just make sure they don't come back too quickly either. That's pretty much the way it works. Okay?
And I have a quick follow-up question.
Sure.
Sorry.
Mm-hmm.
Okay. The follow-up question is, as far as I know, I know the period of authorized stay, or I also know that if you apply 539 and if you leave the country, that 539 is considered abandoned.
Right.
So let's say he applies 539 before I-94 expiry, and obviously the decision is not going to come. But if he chooses to leave up to the date of the extension, actually just to stay close to the date up to which the extension is applied, but leaves before that date, would it not mean that 539 is abandoned because he is now leaving US? And then would it not mean that he has already accrued unauthorized stay, because then your I-94 date would apply, wouldn't it?
No. Law doesn't work like that.
And that would invoke 222G and...
Rahul, let me finish. Law doesn't work retroactively like that. So, abandonment is prospective. Abandonment is from the date you leave the United States.
Okay.
It doesn't go back and negate your initial application. Mm-hmm. So, between the time your application was pending and the time you left the USA, you were in authorized period of stay. Later on, you left the USA doesn't make that authorized period of stay unlawful presence.
Okay.
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 But that's a good question. That
But
is a
then
doubt.
it's not.
Yeah, that is a doubt
Right.
people can very well have. And the answer is the abandonment occurs at the time of leaving the USA and does not reach back and affect your stay while the application was validly pending.
Okay, okay. But then if you stay beyond and if it gets denied, then the 222G might apply if you're still staying.
Well,
because then the I-94 date would apply, right? The automatic revocation of visa.
Yeah, there's more than that. Actually, it's 222G if I remember correctly. But the 222G provisions work a little bit differently. I don't remember exactly the details. I have to look at my notes. In any case, more important than 222G is unlawful presence. If somehow you go over 180 days beyond the authorized period, then you've got a major problem. So I am not that worried about 222G. I am more worried that if you have asked for extension till September 1st and you stay till April 1st of the following year, even if you get an extension, it can only cover you till September 1st. It won't cover you till the April of next year. So you should leave within the time you have requested.
Okay.
Okay.
Okay. Thank you, sir.
You're welcome. Good luck.
Thank you so much.
Good luck, sir. Sorry, guys. I didn't mean to assume, but I guess I did. So my apologies. Going back to, let's see, what were we? This is do. I have a valid H-1B visa for employer A. Wife has an H-4EAD good till 2020. If I transfer my H-1 to B, will I be able to apply for H-4 extension, H-4EAD at the same time? I do believe you are correct that both H-4 and H-4EAD cannot be applied before 180 days of the expiration of the EAD. So I don't think you can. Okay. Yeah, I don't remember the exact law, but I believe 180 days is correct. That is the default period. And I think they created that under the January 17th, 2017 regulations. That's how I remember it. And I think you're right. Star 5, if you have a follow-up question on this, star 5. Okay. Then the next question is from Srikar Tech. Green card interviews for interfiling cases. So what is interfiling? Interfiling basically means that, and it's not really a technical term, but that's what we all use. So it has become a common usage word. Interfiling basically means if you have an EB3 case pending with the 485 and you put in an I-140 approved under EB2 on top of the existing 485. So you have a 485 pending and you want to change the category of your green card. You can do that. So the question that we have is that if you interfile, do we have to go through the interview process? Because my case was filed before 2017 and they were only picking some cases after 2017. And the answer is, I don't have a clue on that. Why? Because this is such a quaternary issue, not even a tertiary issue, that it's not written down anywhere. Okay. My assumption is, and this is very clearly, this is an assumption. My assumption is that you will be considered under pre-2017 procedures where interviews were scheduled sporadically. Because even though you are interfiling today, the interfiling should relate back to the initial filing of the I-485. That is my guess, sir. I can't give you any better than that. I would certainly, if I were you, it doesn't hurt to check with the USCIS. I would call the customer service and I would check with them. Star 5 if you have a follow-up question. Star 5. Okay. Next question is from Nisarg. Nisarg says, my employer has filed an H-1B amendment plus extension in July 2018. Received an RFE. Current I-94 expired Feb 28th. So before your, okay, it's your Feb 2019. Okay, so well before your current status expired, they had applied for an extension. I'm on 240-day rule. I filed a family-based 485, brother sister. Okay, so the receipt was sent on February 16th. I-485 filing date is Feb 16th. I-485 received by the USCIS Feb 19th. So I think what you are saying is this. What you are saying is that the documents were physically received by the government on Feb 16th, but they noted the receipt date as Feb 19th. If I were you, I would argue that it's the receipt of the papers that is the filing date. In my opinion, and I think that's what the regulations say too, if I'm not too far off base, the regulation is 8 CFR, either 203.1 or 203.5. But it's in the regulations that papers are considered to be filed when they are received by the USCIS with appropriate fees. So I think you can very well argue that your papers were received on the date of physical delivery. *5 if you have a follow-up question. *5. Okay. Illinois. Illinois, go ahead, please. Illinois.
Hello, Rajesh sir.
Hello, sir.
Thanks for answering my question.
Of course.
So, sir, in my receipt, the receipt date is of February 19, 2019, and the notice date is March 05. But since my I-94 expired in February 28, 2019, so my question is, if my H1B get denied, then from March 28 to March 05, which is the notice date, so will it be considered as an illegal stay or?
Okay, no, let me get. First of all, it can't be illegal stay. It can only be it can at worst it is only authorized period of stay. But let's look at your timeline one more second. Give me the dates again. When was the 485 physically received by the USCIS?
It's on February 19, 2019.
Okay, February 19th. And your I-94 expired on February 28th, right?
Correct.
Okay. And you are still maintaining status. You are working with the employer, no issues.
Correct.
So you are safe because your papers were physically received within the life of your current I-94. Should not be a problem.
Okay.
Okay?
Okay.
Good luck.
Because they have mentioned in that receipt that notice date is March 05.
Yeah, they can.
And receipt date is of.
Yeah, it's the receipt date that matters. Even their receipt date is in your favor, because what was the receipt date they gave?
They gave me February 19th.
Yeah, so that's confirmed then. It was received by them before Feb 28th, and that's what you need. Okay.
Okay.
Good luck.
Right. Thank you. Thank you very
welcome,
much,
sir. Okay. Next question is from Sat SG, who says, my H1B and I-94 both expired on September 30th, 2018. Employer had filed an extension and an amendment. Case was transferred from California to Nebraska in December of last year. No update in my case. If I don't get any update in the next 2 months, why don't you premium your case? Normally, when you file for an amendment, you are covered by AC-21, not by the 240-day rule. From what I recall, I believe that you can continue working as long as the case is pending. And in any case, you can apply for premium processing. That shouldn't be a problem. *5 if you have a follow-up question. *5. Okay. So Ram wants to know, how is the priority date established? His employer A filed the perm, but he left the company before perm got approved. So obviously, until I-140 is approved, you have no date. Company B started again. They approved the I-140 priority date 2010. So what will be my priority date? It will be 2010. Perm filed with company A does not matter because you did not stay till the I-140 approval. Okay, star 5 if you have a follow-up question, star 5. All right. So Roy Rogers wants to know what is the rule, 180-day rule for filing I-485J. Working with company C, A had gotten an I-140 approved. Then company A also applied for a 485, I guess, recently, 2018, October 2018, received a request for evidence requesting I-485J from USCIS. Okay. I cannot submit 45J until the case is pending for 180 days. I'm trying to think. You filed the 45 recently. Well, this is the petitioning employer. And the reason 45J is being requested is because 485 and I-140 were not filed together. So, excuse me, I'm losing my voice here. So therefore, I don't think you have to wait 180 days because your 485 was filed with the petitioning employer. Okay. The date of signing should be 180. No, I don't think so, because this is employer A. This is the employer who petitioned for you. If you go through employer C, then you should wait 180 days. Okay. So I'm not sure what the other questions relate to, but that's the way. Employer A's supplement J can be filed right now. No problem at all. Don't have to wait 180 days. But C, you should wait until 180 days are over. Employer, sorry, if you have a follow-up question, press star 5. Excuse me. A follow-up question, press star 5. All right, let's see. We have a follow-up question from Oklahoma. Okay, Oklahoma, go ahead, please.
Yeah, Rajiv, this is my question. So how do you determine the 180 days? Is it from the date that it has been filed?
Okay,
for example,
in your case,
I-485.
In your case, 180 days from the date 485 was filed.
Okay, and then does it also mean that after 180 days only the employer C and the candidate has to sign in the supplement J, right? The date of what day?
Are you talking about supplement J with employer A or employer C? Sorry?
Employer C.
Yeah, employer C, you should not file supplement J until 180 days are over.
Okay. The 180 days has been determined. So I have to sign the supplement J after 180 days only, right? The signature should not be before 180 days, right? Doesn't matter what time it reaches USCIS.
I don't think that's the law. But I think that's just a good, smart, common sense policy. Okay.
Okay, Rajiv. So I should make sure that it should reach USCIS after 180 days, and the signature also after 180
That's
days.
the smart thing to do.
Okay. Yeah. Thanks, Rajiv.
Good luck.
Thanks a lot.
You're welcome. Okay. So AK is a family who have not received their physical green card. They have got the green card approval, but they haven't received the physical green cards since February 2018. Now, that's a long time. So I think the easiest way to handle this is contact your congressman's office. contact the local House of Representatives member or the senator and just ask for their help. Say that I need immigration related assistance. I live in your area. You can go to congress.gov, find out who your representatives are. It's on the top right hand side. There is an entry. Find your representative, find your senator. And it goes by zip code, I think. So contact them and they should be able to fix this for you. *5 if you have a follow-up question. *5. Okay. This is an impossible question to answer. What situations could act as triggers for deportation when one living here out of status for over 5 years? Our work is completely with legal people. We have hardly dealt with people out of who are undocumented. So really, I have very little knowledge of this, but I think it will be a difficult question to answer for anyone. It could be something as simple as, depending upon the state you're in, or even the county or the city, because each town has come out on different sides of this, whether they should be assisting immigration authorities in enforcing immigration law. So it could be something like a traffic stop that could get you into trouble. So I don't really know the answer to that question. You need to talk with somebody who works with people who are undocumented. So I'm not going to invite a follow-up question because I don't know anything about it. And the last question for the day is, I think we have time, about 20 minutes for new questions. So this one is about naturalization. I have done my N400 biometrics. I'm from a minority group of religions. The city I'm currently based off doesn't do InfoPass. When should I start following up with the USCIS? So I think you should at least, I don't know what date you filed your N400. Are you on the phone right now? Press *5 if you are. Are you on the conference call? Okay, good. When was your N400 filed, sir? Hello?
Around October 1st, 2018.
October 1st, 2018. And give me 1 second. I don't go to private websites for any information. Give me 1 second.
Okay.
First thing you should check out are the processing times. Which city are you?
Basically, we check it on Google. So right now, so are you asking in my current city?
Yeah, in your current city, do you know what the processing times are?
Yeah, I think it's close to 18 to 21 months.
Give me 1 second. So let's just double check it. N400.
Yeah.
Which field office are you in?
Where I currently live and I filed the application or something.
Right. Which field office jurisdiction do you live in? You're in California, right?
No, sorry. I filed at Dallas, Texas.
Dallas, Texas. Okay. So, Dallas, Texas.
I live in there and I filed over here.
Yes, 1 second. So, Dallas, Texas, according to USCIS website, is 15.5 to 22 months. So, you're not outside that time period. Right now, I don't even know if you should be worried about it, because you're still within the time frame. If it goes over 22 months, then I would start chasing it down if I were you.
Mm-hmm.
Okay.
Good. Besides that, I like your questions as well.
All right. Well, good luck to you, sir.
No, that's it. I like the number 2 and number 3 are then my.
Oh, okay. I thought you said I already have my answers. Okay. May I know what is marital union for naturalization? I haven't specifically researched this issue. I would have to look up the law. But basically, the way the regulations read, as I remember, is that you have to live together. Now, does that mean you have to be physically in the same premises? I I don't think that is the correct definition, because in today's world we had a case most recently where one member of the couple was living in Colorado, the other one was living in Seattle, and they both had jobs. They're both college professors, and that's considered to be living in marital union, even though they're not living together. This is what I remember. Okay, but I have to look up the law. I don't know the answer off the top of my head. Okay.
Yeah, exactly. The reason I asked you is that I'm in a similar state situation.
Well, as long as the marriage is genuine, I think you should definitely, if I were you, I would look at the adjudicator's field manual. Okay. USCIS has, we have a few minutes. This is an interesting question.
Yeah.
Let me see what the...
Yeah, the reason I'm asking you is that I mentioned it in my second point.
1 second. So if you go to the USCIS policy manual, select the volume, citizenship and naturalization, spouses of US citizens, I think it should be quite clear there. Marriage and marital union for naturalization.
And recently...
1 second. 1 second. They talk about marriages. Okay, living in marital union. In general, all naturalization applications filed on the basis of marriage must continue to be the spouse of a U.S. citizen at the time of filing of the naturalization. The applicant does not meet the married and living in marital union requirements if they're not residing together. There are limited circumstances where an applicant may be able to establish that he or she is living in marital union even though they don't actually reside together. So yeah, there is a way you can establish that, and it's under footnote 21, and there is a guidance by the USCIS, 12 USCIS PMG. So failure to live, informal separation, involuntary separation. So required travel or relocation for employment is considered to be excusable. Okay. As long as you are together as a couple, even if you live in different towns. That's what I thought the law was, because we just did it recently. I don't think it should be a problem. Okay.
Yeah, so the reason I mentioned to you is that I mentioned it in my second point. Are there any exceptions to living together?
I just told you that. I said there are 2 exceptions given by the government.
Sure. Okay.
Service in the U.S. Armed Forces or required travel or relocation for employment. Very clearly.
Yeah, exactly.
Okay.
Exactly. Mine is a similar situation. In the past few months, I've been traveling for work.
Yeah, that's
maintaining one permanent address for any.
By the way, I just come to remember another case. We did that last year, where the husband was on the ship most of the time, and he was serving. I think he was doing oil exploration. So he was on the ship 8 months or 6 months a year, and the wife was a teacher. She was somewhere else. We had no issues getting the naturalization through. All right.
Okay. And recently, while filing taxes, also I filed as a dual state resident.
Yeah, I think you should be fine. I have to take my other calls, guys. All right.
Okay. Sure. Sounds good. Thank you so much.
You're welcome. Good luck. I was curious about this myself. I don't think it's going to be any problem. Okay, so I guess these are all the questions. Let's open the floor for any new questions, guys. Anyone has any question, press *5, please. Okay, I've got 1, 2. All right, please, if you have any questions, raise your hands now. All right, so we'll just do these 2 questions. First one is from Nashville, Tennessee. Tennessee, go ahead, please.
Yes, sir.
Yes, sir, go ahead.
Sir, actually, my name is Sharma. Actually, I'm working on religious visa as a priest.
Okay.
Recently, I got married, and my wife go for interview in India.
Right.
Actually, first we got visa first available date in Chennai, sir, but later we got first available date in Kolkata, so we rescheduled to Kolkata consulate, but they denied visa for R2 dependent.
Was the ground 214B?
Yes, sir.
Yeah, they have been doing this a lot in our visas. They are doing it for both the main as well as the derivative beneficiaries. So I'm not sure you can do much about it except when you get your green card, they'll have to give her a green card. They can't keep her out. So if I were you, sir, I would look at doing the green card. Okay.
Other than that, can I reapply?
214B.
Can I go through another?
No, 214B denials are very difficult to overcome. I don't know your case, but I'm just talking generically, and I'm aware that they have created a lot of problems for our visa people. Okay.
Oh.
This is a common problem.
Thank you very much.
Good luck, sir.
Thank you.
Okay, so let's get this question from California, which will be our last question. California, go ahead, please. California.
Yeah. Thank you. Thank you very much.
Yeah, can you speak up a little bit? You're a little unclear.
Yeah. This is one of my frequently asked questions. This is about the green card. I got my green card on Feb 2019.
Okay.
As EB1C, category
right.
EB1C.
All right.
Now I'm looking for a change. Do I need to change into similar position, or I can change it as independent contributor instead of
Did you say you got your green card approval in Feb of 2019?
Yes, correct.
Okay. Well, there is no law that says you've got to get stuck with the same employer or the same type of employment forever. But the smart thing is to hang on a little bit longer. The law is that on the date you get your green card approval, you should have no intention of leaving that employer. So permanent intention to work means you want to work there without any end in sight. But if a few months later you change your mind and you want to do something else, that should be fine. But if you leave too quickly, intent being a state of mind can only be demonstrated by your actions. So therefore, if you can wait a few more months, that would be a good thing, even though the intention to stay is only required at the time of the green card approval. Okay, so if you are going to move right now, I would take a same or similar job. And after a few months, if you want to quit and become a free agent, that's your choice. You should be fine.
Okay. So the choices are I need to wait for a couple of months, then I can take a same or similar job.
Right. You can take a same or similar job now if you want. I don't see any problem with that. I think that should be okay. But if you can, so my recommendations for the least amount of trouble would be stay with the same employer a few months if you can. If you cannot, take a same or similar job somewhere else for a few months. And if nothing else, then you do a same or similar job for yourself.
Okay.
Good luck.
So how about the independent contributor?
Like an independent contractor? I think if you become an independent contractor, you may want to go in as an employee of your own corporation. Okay. So go in as an employee of your own corporation. It's a little complicated. If you decide to do that, I would suggest you seek a consultation with an immigration lawyer. But that's certainly an option. Remember though, my first choice is stick with the same employer for a few months. Okay?
Do you have any timeline, sir?
No, I don't think there is any timeline. But if you get approval in February and you leave in April, it indicates that you were already planning to leave.
Okay.
That's all it is. Now, I've had cases where, I'll give you an example, and that's a very good example actually. I had a case where somebody got a green card approval through their consulting company. And the consulting company actually were okay to let the employee go because that same employee got a very good job offer with the client only 2 or 3 weeks after he got his green card approval. The interesting thing is that there was no prior plan of that job. The position opened up and we could prove it if we are required to. We could prove that the job opened up suddenly, and because he was working as a contractor for that end client, he got hired. So if circumstances are sudden, all of a sudden you were not planning for it, but you got a job offer which is very lucrative, I have no problem you taking it, as long as you don't have any plans before you got your green card approval.
Okay. Got it.
Good luck, sir.
Thank you, sir.
Always a pleasure. Good talking to all of you folks. I look forward to talking with you again, hopefully in the next 2 weeks, as we normally did. At least for a while, we can try to keep doing that. Good luck, folks. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time, every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.